32,000 per square kilometer, which would make it number 2 in the world. So there's not much scope for fresh development because there's so much development that has already taken place. But therefore, it is redevelopment that is taking place. Now, under which law does this redevelopment happen? It is under the Maharashtra Regional and Town Planning Act 1966. So this law has been there for almost 50 years. The municipal, almost 60 years. The Municipal Corporation of Greater Mumbai is the planning authority for the jurisdiction of Greater Mumbai. Section 21 says that the planning authority shall prepare a draft development plan and development control and promotion regulations for Greater Mumbai 2034 have been prepared. Usually when there is a law, such as the Maharashtra Regional and Town Planning Act, the year in which it is promulgated is mentioned there. So it says the act is of 1966. But it says that the regulations are of 2034. Which means not that they are made in 2034, but they are for the period from now until 2034. These are regulations and not the act itself. Now, Regulation 2 into bracket 61 defines FSI, or Floor Space Index, as being the total covered area on all floors divided by the gross plot area. That's how we come to the FSI. We are all familiar with that term. That the we are all familiar with these terms, and we know that up till a few years ago, the FSI in South Mumbai or in the island city was 1.33, and the FSI north of the island city, that means from Bandra onwards, the FSI or floor space index was only 1, which meant that if there was a plot of say 1,000 square meters in the island city, then you could construct 1,330 square meters of total constructed area. Whereas in the suburbs, the FSI was only 1, which means that the buildings did not use up the full land. Then the concept of TDR, transferable development rights, came in about 1994, at which point of time this was not available in South Mumbai or in the island city, it was only available in North Mumbai. So therefore, one could acquire TDR, transferable development rights, from someone who had that right, and then be able to utilize it on a plot of land. Now, how was this TDR generated? TDR was generated when land was acquired by the municipal corporation. In the old days, if land was acquired by the corporation, then there would have to be a compensation. So if they took 100 square meters, then they would have to, if they took 100 square meters of land, then they would give you payment for that 100 square meters. But that resulted in so much litigation that then they decided that they would give you the right to construct. So they gave transferable development rights. And therefore one could use the DRC, Development Rights Certificate, in respect of that TDR and go to a building which is already existing and say that we will reconstruct your building because now we've got more FSI under the TDR scheme. And that's how the development was taking place. In South Mumbai, that was not available because TDR was not for use here. It was only that there were some kinds of TDR to a limited extent, heritage TDR, which could be used even in South Mumbai. But then in the last few years, everything has changed. And now the government has decided that they do want to be able to construct more and that Mumbai should get transformed, that there should be much more TDR available. There are certain other things that have happened, which I would just like to mention. One is Regulation 2 into bracket 65 defines fungible compensatory area as any built-up area permitted over and above the admissible FSI by a special permission of the Commissioner in accordance with Regulation number 31(3). So, fungible FSI is available. What had happened was that there was a municipal commissioner in Mumbai, Mr. Subodh Kumar, and When he came here and he looked around and he said he saw so many approvals where builders were constructing buildings which would have a lot of flower beds. So he said there are more flower beds in Mumbai than there are flowers. And this must change, because what everyone was doing was that they were constructing these areas which were shown as flower beds on the plan, which were about, say, 1 foot below or a few inches below the level of the floor. And then after the occupation certificate came, then they would remove the wall and go down one step and say this is a part of the flat. So therefore he said, no, this is not acceptable. Flower beds and lily ponds and so on are not going to work here. Therefore, we will give fungible FSI. Fungible means that you can use it in any way that you like, but you have to pay for it. And this way you have to pay to the municipal corporation. If you had your own FSI, there was no payment for that. If you acquired TDR, then some individual or whoever had surrendered the land would get that payment. The corporation was not getting anything. But by the fungible FSI concept, one could pay the municipal corporation and get additional FSI. And that was the start of the increase in FSI regulations. There's one other thing that I would just like to mention, and that is Regulation 2 into bracket 124. This doesn't talk about FSI or floor space index. This talks about volume to plot ratio. This says volume to plot ratio, VPR. We don't use this in Mumbai, but it seems that they do use it in other places, like in Hyderabad, where they say that you may construct. We are not going to tell you how many floors you can construct, but it is the volume of the building. So therefore, you may have a building of say 10 feet per floor, or you may have 12 feet per floor, you may have 20 feet per floor. We are not concerned with the FSI, but with the volume of the building. Now that's not something that we are using in Mumbai. It was just an unusual concept when I heard it, but I'm surprised that the development control regulations actually make a reference to this volume to plot ratio. Then Regulation 3.1 says these regulations should apply to all development and redevelopment, change of user, etc. Rule 30, Regulation 30 relates to TDR. And then we come to Part 6. Part 6 contains Regulation 33. 33 has many sub-regulations. And I've just listed out these, which will show you the different ways or the different uses to which one can get, or for which one can get additional FSI. Regulation 33.1 relates to religious buildings. So if a building is a religious building, a temple, a mosque, a church, etc., then they can get additional FSI under Regulation 33.1. Many times for this additional FSI, there is payment. In some cases, there is no payment. Sometimes there are payments at different rates, usually in relation to the stamp values. So it can be 60% of the stamp value rate or 50% of the stamp value rate, etc. But additional FSI is given under Regulation 33. So for 33.1, it's for religious buildings. 33.2 is for medical and educational institutions and other institutional buildings. 33.3 is for government buildings. 4 is for building of residential hotels on independent plots. 5 is for development and redevelopment of housing schemes of MADA, which are undertaken by housing cooperative societies or by the occupiers or lessees of MADA. Then 33.6 relates to reconstruction of buildings which are destroyed by a fire or which have collapsed or been demolished under an order. 33.7 is important for us. This says that if there is a reconstruction or redevelopment of a cessed building in the island city by a cooperative housing society or an old building belonging to the corporation, then additional FSI will be used. So 33.7 is important for most purposes and for our subject today. 7A relates to reconstruction or redevelopment of dilapidated or unsafe existing authorized building is existing, it's dilapidated, but so you can see how many adjectives. Dilapidated or unsafe, existing, authorized, tenant-occupied building, and non-cessed tenant-occupied buildings. Then 33.7b is additional FSI for redevelopment of existing residential housing societies. So therefore one may do it under 33.7 or one may do the redevelopment under 33.7B. And then under 33.9. Now 33.9 gives actually the maximum amount of FSI because this is for a cluster. The cluster concept was introduced about 15-20 years ago, and if a building or a group of buildings occupies at least one acre of land, that is 4,000 square meters in metrical terms, then it can get additional FSI. If the area of the plot is 4,000 square meters, then you get a particular FSI. If it's 6,000 square meters, it'll be more. If it's 10,000 square meters, it'll be even more, etc. Now the FSI is relatable to two factors: the kind of activity that you want to do or the kind of redevelopment that you want to do, and also the width of the road. So if a road is giving access to that plot is of 6 meters width or 9 meters or 12 meters or 18 meters width, then the FSI is different, because so many more people are going to be housed on a plot that they have to see that fire safety is there and that there's enough for traffic and so on. The FSI now that is given in South Mumbai, for instance, is not just 1.33, but it also depends on the FSI that has already been consumed by the existing occupants. So you will get that much for rehabilitation of the occupants. You can get fungible FSI, as we talked of just now, some of it free of cost, some of it at a cost, and you can get incentive FSI. So the FSI in South Mumbai can go to 3 or 3.5 or 4 as against the 1.33. And in some cases, in extreme cases, depending on the width of the road and the number of occupants and the area that they are using, etc., the total can go up to about 5.5 or 6. Now this is set out in very great detail in the Development Control Regulations. In fact, in the book on the DCR, as many as 136 pages are related to the calculation of FSI. So for every category, there are so many things, that 5% additional FSI for this, 8% for this, 6% for that. So therefore, it's a very precise thing that one has to work on. Now, in a cluster redevelopment also, they will take into account all of these. There are different categories for buildings, slum areas, land pooling for the cluster redevelopment scheme, the total FSI, etc., and slum rehabilitation. Then Regulation 3313 relates to IT establishments, information technology, not income tax. 3316 relates to development of multi-story public parking lots, and 3324 relates to redevelopment of tenanted buildings belonging to MADA. Now, many people are interested in all this going on. Mark Twain said, they are not making any more land, so buy as much as you can now. We are not making more land, but we are able to develop so much more. That is where the value gets created. And everyone is interested in vitamin N. Everyone wants the vitamin money, and therefore every builder is anxious to get a development project. So many builders talk to me and say, are there any societies which are going in for redevelopment and so on, and we would like to participate in that process. And societies also naturally want to be able to do this, because the flat owners will get a bigger area, 15% more, 30% more, 40, 50% more, and they will get a sum of money. They will also be able to get money for alternative housing during the period of the construction. So it can be a wonderful project for both, for developers and for those who are living there. What the future holds, we do not know. Because will there be an oversupply? Will it be that Mumbai cannot take this anymore? What about water? Parking, of course, will be available in the building, because when a new multi-story building is made, there will be 3, 4, 5 levels of parking. So there will be much more parking in buildings than there is now. Maybe that will reduce the pressure of parking on the streets. But if while people may have parking spaces in their own buildings, when they go out somewhere else, will they get parking over there? Well, there'll have to be more parking lots, etc., or there'll have to be much better public transport. So what the future holds, we do not know. But we have to be ready for this because the time to do anything is now. This is when the maximum opportunities are there for developers and for societies and for individuals. So how should one gear oneself up? How should one be in readiness for this kind of development? There are processes under the law. There are legal implications. But first, we will talk about what a society should do before it engages in those processes. Our presentation today will cover 4 things. One is I'm talking about the FSI and the general aspects. Then Ms. Divya Alexander, advocate, will talk about Section 79E of the Maharashtra Cooperative Societies Act. Mr. Adhiraj, Harish, advocate and partner of the Accommodation company, will talk about the agreement and the kind of terms that come up, what builders will want, what societies will want, and how to be ready for that, how to negotiate, how to discuss, and how to reflect it properly in a document so that it's very clear and there are minimum problems that arise in future. And Ms. Mrugakshi, Joshi, advocate, will talk about the tax implications. Now, before we come to the first one on Cooperative Societies Act, what should a society do in order to be in readiness for this? One is they must do their homework. It's not that you just go out and look for a developer and start negotiating there. You have to be ready yourself for what it is that you have and what you want. So you must check your title and documents. Do you have a conveyance? When the builder earlier constructed the building, did he give you a conveyance? Maybe you have it. If not, then you should try and get a deemed conveyance. Then is your property card property reflecting your ownership, the ownership of your society? If it's a leasehold land, then does the lease permit you to do the development, or do you have to go back to the lessor of the land in order to get his permission in order to go ahead? A lessor may not have allowed you to assign it. You know, the agreement, the lease deed may have said, this lease is in favor of the cooperative society, and not mention its assigns. Many times it says successors and assigns, but suppose that is not written there, then you may not be able to go ahead with development. Or if there's less than 30 years left for the lease, then again the municipal corporation may not accept any redevelopment without the lessor's permission. So you have to check your leasehold documents. Have all members registered their documents when they purchase? Now we know that that in the old days, people did not register their documents in a cooperative society. Why? Because Section 41 of the Maharashtra Cooperative Societies Act provided that in the case of a transfer of premises in a cooperative society, registration was not compulsory. And there's a decision of the Bombay High Court to that effect also, Usha Dongre versus Suresh Kotwal. This issue still comes up because in the 60s, 70s, 80s, and even early 90s, documents were usually not registered. Now, of course, everyone registers, but in those days, they were not registered for several reasons. One, it was not required under law. Two, in those days, the registration fees were 1% of the value. Now they are 1% subject to a maximum of 30,000 rupees. So today, if you do a flat transaction of 10 crores, if that cap had not been there, you'd be paying 10 lakhs for registration. In the old days, if you did a flat transaction of 2 lakhs, you had to pay 2,000, which was a lot of money in those days. It was the equivalent of maybe 1 or 2 square feet of space. So, have all the members got registered documents? If not, at least have their documents been stamped. There has been the amnesty scheme, so many people have taken advantage of it, but one should ensure the documents are stamped. Even if the amnesty scheme were to be over and you realize this, then go to the stamp office, pay the stamp duty, pay the penalty also, but see that your document is proper, because that is very useful. That's what a developer will look for. It's not these things. In these things, there has to be an alignment of both sides. The society has to be clear about what it has and what it will give, and the developer will also be clear. He'll say, this is what I want from the society. I need to have proper title. I need that everyone should have proper documents, and I need that there should be a conveyance or a deemed conveyance. Then, the society itself should check the availability of FSI. This is linked, as I said, to the width of the road and all these other factors, whether you go under 33.7 or 33.7B or 33.9, etc. And for that, you must get an architect. These are very complex calculations. You have to see how much existing FSI has been used, how much more can be used, look to the width of the road, and go into it in detail. It's important because only then will the society be able to negotiate with the developer. And the developer, of course, is going to do his own study, so he will also know all these things. There are a couple of other important points that you need to bear in mind before you begin the process. GST can be important, but usually this is taken on by the developer. But a society must discuss this, and the developer must also discuss this so that it's clear in the document. Then the stamp duty. For quite some time there was controversy on how much stamp duty has to be paid on an agreement for permanent alternative accommodation, a PAAA. And the stamp office would say, well, you paid stamp duty on the development agreement, but when the builder is telling you that instead of your 1,000 square foot flat, I'm going to give you a 1,400 square foot flat, then you have to pay stamp duty on that. So people would say, well, why should we pay? Because after all, it's all a part of the same development. And Section 4 of the Maharashtra Stamp Act says that if one document is stamped, then other documents in relation to that same subject matter can have only to be stamped on 100 rupees. But the stamp office would say, well, if your society entered into a development agreement with the developer, are you as a flat owner a party to that? You're not a party to that. If you're not a party to that, then how will you get the benefit of Section 4? It's not a third party who can get it. It's only the parties to the document, which makes it very important, therefore, that when a development or a redevelopment agreement is done now, then there should be three sets of parties. There should be the society, there should be all the members as confirming parties, and there should be the developer. When they are all members, then stamp duty is paid on that. When you get your alternative accommodation agreement, there also one view is that it should not only be between the developer and the member, the society should also be a confirming party. So that you can say that all three of us were parties here, all three of us are present. There were many others also. But at least for my flat, I am eligible for this concession of only paying stamp duty of 100 rupees rather than with reference to the full market value of the law. Now, there are a few other things. A society must go into all these aspects. And it takes a lot of time before you actually start talking with the developer. You must understand from your architect what the size of your building is and what the FSI will be. You must go into the feasibility. You must see what the costs of the society are going to be, because the society also should have its own architect and its own engineer in order to be able to supervise the construction. As the developer will see it also, then it will be easier for the developer also to talk and relate to the architect and explain to the architect and engineer what needs to be done. The members of a society must also do their amenity planning. What is it that you want? How many car parking spaces? What about terraces? That becomes a subject matter of great controversy, that one or two people in the building have a terrace. So everyone has a flat of 1,000 square feet, one person has a flat of 1,000 and a terrace of 1,000. See, on the top floor there's only one flat. He'll say, why should I give up my terrace and get a flat of the same size? I want something more. Now, how much more should he get? Is there only one terrace flat in the building? Are there more? How should they negotiate that? How much more should he get? It's better to iron out all these things before you get into the actual discussions with the developer. Then, if someone has a garden, he's on the ground floor, he has a garden, then that has to be taken into account. What are the other things that the building will want? Will you want a gym? Will you want a swimming pool? Do you want solar panels? Do you have to have enough water supply? Your electricity, of course, has to be sufficient, many of which things the developer will do, but you have to go into that. You will also consider whether it is worthwhile for your building to carry out self-development, because the law permits that you can go deal with a developer or you can do a self-development. If you do a self-development, there are some advantages in that you can get more FSI, but there are also some restrictions. One is that you have to complete the project within 3 years. So that is very difficult except for a small building. And of course, if you are going to do a self-redevelopment, then you have to put in all the costs, whereas now the developer is going to take care of that. So you will have a person with a good reputation who has got a lot of experience. You will check out his track record and then be able to deal with it. You may also see whether you will get a bank guarantee from the developer for completion and what are the consequences if it is not completed in time. So all these things are very important, and now we go on to the next step, that is of the cooperative societies. So remember, we are not just buying land now or just buying additional space. In the process of redevelopment, we are going to shape our own futures and the future of our great city. Thank you.
Could you introduce your group?
This is Ms. Divya Alexander, advocate. She's done her LLB from Mumbai, and then she did a master's from Queen Mary College in London. And she's been with us now for more than 11 years.
Hello everyone, thank you for having me. So we'll just get right to it. To understand the topic with respect to the redevelopment of housing societies, it is first important to have some sort of background understanding as to what is the law that governs housing societies and what are the directives that apply to redevelopment of housing societies. So housing societies are governed by the Maharashtra Cooperative Societies Act 1960. Now in 2019, there was an amendment and a new chapter, Chapter 13B was introduced specifically for housing societies. However, Section 79A from the unamended Act continues to be applicable to housing societies. Everyone's been talking about 79A, so now let's see what 79A is and what it actually states. So 79A is a section that allows for the state government to pass directions in public interest. And these must be followed by the managing committees of housing societies. 79A has not come in for the first time with respect to redevelopment. It's been relied on in the past, and several directives have already been passed under 79A. For instance, and I'm sure all of you will relate to this, transfer fees which have been capped at 25,000, that came under a directive under 79A. The non-occupancy charges being capped at 10%, that was also a directive under 79A. Even election procedures to managing committees come under the 79A directive. So this is essentially what 79A says. Now under 79A, the state government, which is the Maharashtra state government, has passed a special directive in relation to redevelopment. These directives, the first one was passed in 2009 and then a second one was passed in 2019. Since this 2019 directive supersedes the 2009 directive, let's understand this 2019 directive and take it on a step-by-step basis. So essentially the 2019 directive can be broken down into 6 steps. These steps are, broadly, the first one is the SGM stage. The second one is a feasibility report stage. The third one is a tender stage. The fourth one, the authorized officer stage. The fifth one is the second SGM stage. And all these 5 steps put together then come to the final step, which is the development agreement stage. Now let's take it step by step, and we'll begin with step number 1, which is the first SGM. In any housing society, the process of redevelopment has to start with an SGM. The SGM can either be requisitioned by the members of the society or it can be called for by the managing committee. Unlike other SGMs, for which usually there's 5 days clear notice, for this SGM there has to be a 14 days notice. And there's another specific rule. The quorum has to be 2/3. If the quorum of 2/3 members is not satisfied, you can recall the meeting within a month. But even if it's not satisfied at the second time when you recall the meeting, it has to be called off. And it cannot be recalled again for 3 months because it would be understood that the society does not want to proceed for redevelopment. Now, what is the decision that has to be taken at this meeting? Essentially, there are 2 points on the agenda of this first SGM. The first is the decision as to whether or not to do redevelopment in the first place. And the second is the appointment of a PMC or an architect. Now, the decision which has to be taken by 51% of the total members. Not 51% of the 2/3 quorum, but 51% of the total membership. This is difficult to satisfy, but this needs to be done as a step. So now that the PMC is appointed and the society has decided it wants to go ahead for redevelopment, we go to stage 2 or step 2, which is the feasibility report stage. So the PMC is required to submit a feasibility report within 2 months of his appointment to the managing committee. The managing committee must then take suggestions from the general body and finalize this feasibility report with the PMC, and then this feasibility report is to be approved by a majority of the managing committee. Although the general body is not required to be involved at this stage, it might be useful at times to have another SGM at the option of the managing committee to discuss the feasibility report. However, the law does not mandate it. We then go to step number 3. So once this feasibility report is approved, the next step is that on the basis of this feasibility report, the PMC can now draw up tenders and invite developers. So the steps are that the PMC prepares the tenders, which are approved by the managing committee. At least 3 tenders must be received. If 3 tenders are not received, then there are provisions where you can extend the time for the receipt of tenders and call for the tenders. But at some stage, there has to be an end date. And even if there are less than 3, whatever is received will have to be considered. The PMC will then have to make a comparative table of the 3 best tenders, or whatever tenders are received if they're less than 3. Once the 3 tenders are selected, the next step is that the general body has to now choose from one of these 3. But this can happen only in the presence of the registrar's office. So we come to step number 4, which is the appointment of the authorized officer or the EO. Not the assessing officer in income tax, but this is a different EO, the authorized officer. So in step 4, the managing committee must make an application to the registrar for the appointment of the authorized officer. And within 1 month of his appointment, the SGM can be called for. Again, there is a 14-day notice. But this 14-day notice must necessarily be sent in writing as well, so it's not sufficient to have any form of oral notice because the law mandates that it must be sent by registered post, mail, etc. And so we come to step number 5, which is the second SGM. In this SGM, the general body, the developers, the PMC, the authorized officer, everyone is present. This SGM has to be video recorded. The same rules for quorum and decision making will apply at this SGM as well, which means the 2/3 rule and the 51% rule. Now, what happens in this SGM is that the 3 selected tenders are presented, and the general body then chooses one developer. And that brings us to the final step, which is the signing of the development agreement. Now, the development agreement is to be signed within 3 months of the selection of the developer. The details of what clauses a DA or a development agreement should cover and what protections society can avail of will be covered by Adhiraj in the next segment, so I'll leave that to him. But there is one other point that the directive covers. It says that the new units to be allotted should be allotted on the same floor position. So if you have a flat, let's say on the 2nd floor, then even if the new building has podium parkings or basements, lobby levels, etc., your new flat should be located on the 2nd habitable floor. If, however, this is not possible for any reason, then the floor has to be decided by a draw of lots. But it says that this draw of lots can happen only at completion, which is after the OC is received. So the question remains then what happens in your PAAA or your permanent alternate accommodation agreement? What is the flat number that's to be written in that? There are some other points as well. For example, most societies put up all of the information on a notice board. But this directive states that a society must also maintain a website to update members on the redevelopment process. As we have seen, this directive only mandates the video recording of the second SGM, where the choosing of the developer occurs. But as per a circular of 2010, all AGMs and SGMs should either be audio or video recorded, so it might be a good idea from now on to just have a recording at your AGMs and SGMs. Considering the various points that this directive has, we come to the most important question. Is the directive under section 79A mandatory? The courts in various cases which I've listed below in the slide have settled certain principles with respect to the redevelopment directive. The first of these is that the general body is supreme. As we saw in the beginning, 79A directives are usually passed in public interest. And the courts have held that public interest cannot outweigh the interests of a special body, which is the general body. The second principle is that the view of the majority binds the minority. The directives under section 79A of the Cooperative Societies Act is not mandatory and substantial compliance is sufficient. Now, this was actually in a case where one dissenting member got up and went to court simply on the ground that his society had not maintained a website. Everything else was followed. And the court said that, it's really not important. Everything else has been complied with. The GMs and SGMs have gone according to plan, and therefore, on this basis alone, we are not going to say that 79A has to be followed to the T. Directives under section 79A of the Cooperative Societies Act do not bind the third party. Developers are not bound by this process. This process binds the managing committee and by extension its members. It does not bind a developer. Decisions taken in accordance with the principles of democracy, which is how your SGMs are conducted and your AGMs are conducted, cannot be interfered with or displaced unless the same was sanctioned by fraud or misrepresentation. There is also another part of 79A that has somewhat been rendered redundant, because the 2019 directive under 79A said that all disputes between developers and societies and or their members must be settled through the section 91 process, which is through a cooperative court. And the Bombay High Court has said that section 91 applies when it's the business of a society. And redevelopment is not a business of the society, and therefore 91 cannot apply. So although this continues to be part of the 2019 directive, it's been rendered somewhat redundant. So now we'll proceed with how a development agreement is to read and the protections offered to a society, how a PAAA should be, and for that I'll call upon Adhiraj to take over.
Hi, am I audible?
Yes.
So, when we talk about redevelopment of a society, there are three main documents. There will be other side documents and maybe some undertakings and letters and so on. But there are three principal documents which we will go through. The first is the development agreement. So the development agreement is typically the document between the society, the developer, and as Mr. Harish earlier explained, it's all the members who will also become confirming parties. The reason mainly for this is, again, that each person will get their own title document separately, and if they are not a confirming party, chances are that they will not be entitled to the stamp duty benefit at 100 rupees. They will have to pay stamp duty in full. Therefore, it's very important that the members are made confirming parties to the development agreement. Of course, the development agreement has to be stamped and registered, and it has to cover several different important clauses and provisions. The first thing that it should cover is the total development potential that the developer plans to exploit. So supposing the developer is going to exploit, or say the society has agreed with the developer on a 50-50 sharing. So if the developer is going to say use 40,000 square feet and give the society 40,000 square feet, tomorrow during the course of construction, if 10,000 square feet becomes available due to a new scheme or something like that, then that should be mutually decided between the society and the developer as to how they want to exploit it. Some developers will often try and say that, look, we are giving 40,000 to the society, everything beyond that is ours. That also happens sometimes, but societies need to be careful because they generally also should get a share in the upside if it comes. The next is, of course, the carpet area, whatever society has negotiated, whether it's 10%, 20%, 30%, 50%, whatever extra area that you could get, that should be very clearly stated in the development agreement. The location, the floor Divya spoke about, should as far as possible be on the same floor, but if not, then it's by row of lots. And as Mr. Harish said, the amenities, one should sit down and see whether you want Italian marble, or you want Jaguar fittings, or whatever it is. You should discuss all of these things with the developer, because all of these become small issues and which can escalate to bigger things subsequently. How many car parkings are going to be entitled with each flat? So now it's not the developer's responsibility to allocate or demarcate the spots. They will tell the society, we are giving you 40 spots. The society will then internally with its members decide who's going to get the first spot and the second spot and the third spot. But it's important that how many, whether it's going to be mechanized parking, whether it's going to be basement parking, whether it's going to be on the ground level, all of these things should be clearly ironed out in the development agreement. The next is rental compensation. So obviously, because you're going to have to move out of your building during the redevelopment process, you should look at the area in which your building is right now. What is the size of your flat? And you should ideally be able to move in rent in a similar size flat in a similar area. So if you're in Khar and you have a 1,000 square foot flat, you should look at the rentals in that area and try and negotiate that with the builder. What people often forget, and many clients have spoken to us in the past, and what they've forgotten is that whenever you go on rent, you have to pay brokerage, you have to give a security deposit. Now these things people quite often forget. So that's an important point that one has to discuss, especially the brokerage. The security deposit will come back to you eventually, but the brokerage is an expense which has to be incurred. So one should try and negotiate that as well from the developer. The next is corpus. You're going into a redevelopment because you want a better building, you want better amenities, maybe a swimming pool, maybe a gym, maybe a garden, which right now probably is not there. So the maintenance costs are going to be far more than they are today. It's going to be a newer building, and now the size of the building will be much more. So one has to negotiate a corpus so that the maintenance charges to some extent are offset, and each member doesn't suddenly have to start bearing a maintenance cost which is 10 times what they were bearing earlier. Next is hardship compensation. Now, every member who has to move out is undergoing hardship. They are being displaced from their homes for 2 years, 3 years. They have to look for a place on rent. They have to pack all their belongings. They have to move it. Some of it will go in storage. So there's a lot of hardship faced by each member. So therefore, there is a lump sum amount which is usually negotiated also, which is called hardship allowance. Now what's important is the timelines for the completion of the project. What 79A also suggests is that it should be completed within 24 months or at the most 36 months ideally. Of course, the development agreement will contain extensions for force majeure, supposing there was a pandemic, this affected everyone. But ideally, you have to ensure that it's within 36 months. And of course, if there's going to be a delay, then there has to be consequences. Your rent has to go higher. There should be some penal consequences and not just continuation of rent. So that has to be negotiated with the developer as well.
So this will be a tri-party agreement, or it's a three-agreement different?
No, there will be one development agreement. There will be a separate power of attorney, and there will be a separate PAAA agreement for each member. So there will be several agreements involved. And the builder will ask for different undertakings, and there will be several notices that will be along with it. But we're discussing the main agreements, which are these three. Now, we've discussed what it should cover and what are the different points that one has to ensure that they get. But how do you protect yourself? So the first thing is a guarantee. Now suppose you go to one of the best builders in town and they've got a great reputation, they've done very good buildings, but they're doing the project in an SPV. An SPV means a special purpose vehicle, which they set up a new LLP or a new company just for this project. That means they don't have any other assets. Tomorrow if something goes wrong, who will you chase? This is a box. There's nobody else behind this. So you have to ensure that you get a guarantee from the developer's main company or from the promoters themselves, because you're going on the basis of their reputation. Second is no assignment of development rights. As we discussed, you've selected the developer because of his track record, because of what other projects he's completed. So you must ensure that he can't pass on the buck to someone else. If he gets a little bit more, he should not be able to transfer his development rights to another developer. He must complete the project. Next is a bank guarantee. Now, as Divya had also pointed out, in 79A that a bank guarantee is also provided for, which is usually, it's mentioned in 79A that it should be 20% of the redevelopment project cost. This is often negotiated because 79A is not mandatory, but has to be in substance. So this will be often negotiated, but you have to try, a society has to try and get as much of a bank guarantee as they can. Next is a security deposit in the completion of the defect liability period. So first is a defect liability period. Now a defect liability period is given to flat purchasers when they purchase from RERA, for example, under RERA, when they buy from a builder. Therefore, if there's any structural defect or anything within 5 years from the time the OC is received, the builder has to take care of that. He has to repair it. If there's any leakage, any structural cracks and so on, this is the responsibility under law of the developer. But this is different in the case of a society. Therefore, society must say, we also want this defect liability period for 5 years. And ideally, you should try and take a security deposit at the very beginning. And it may be a smaller amount, but you should try and hold it till the end of 5 years. So if some cracks come up or there's some leakage, you should be able to use that deposit or use that guarantee to repair it yourself if the developer doesn't do it. Because it's very hard to chase someone later. And like I said, if there's a special purpose vehicle, once the project is over, there's not much left in that company. So it's very difficult to follow up on that. Then of course for rent, you should try and take maybe as much as you can at a time. If you can get 12 months at a time, that's great. If you can't and it's going to be on a monthly basis, you should get post-dated checks so you don't have to chase someone every month, you don't have to chase a society, you don't have to chase a builder. You should try and get post-dated checks. Okay. The next is possession to be handed over for the rehab component first. The society, the land belongs to the society. All the members of the society have been there all along. The new persons have bought from the builder. So it's important that all the members of the society must first get possession and not the new buyers, because they are the ones who have to be protected. They parted away with their homes and everything that they have. So this is an important clause which you must insist on, that before you give possession to any purchaser, you must first hand over the possession for all the members. Then of course increased compensation for delay, we touched upon this, that if the project goes beyond 36 months, then you should try and get some penalty on the rent and additional consequences so that this is a deterrent. Now, secured premises. What this means is, most development agreements now often, the societies tell the developer that you must earmark 1, 2, 3 flats depending on the size of the development and the cost of the flats, in case the developer defaults. Supposing the developer defaults, then the society must, in addition to the bank guarantee, they must have something more to cover the cost of the construction, because then they'll have to step in and do that themselves or find someone else to do it. So the secure premises is like I said, 1, 2, 3, 4, how many ever flats that are required should be set aside, which the developer cannot sell. It's locked up until the project is completed and then the developer is free to sell it. Or the developer might say on milestones. So for example, if he's completed 8 slabs, then 1 flat can be released. Or if he's completed the next 4 slabs, then another flat can be released. So it depends on negotiation, but these premises are important. They cannot be mortgaged, they cannot be sold until the terms and conditions of the development have been complied with, because if there's a failure, you have to step in, sell that flat, the society has to sell that flat, recover money, and then complete the construction. Next is that an indemnity clause. Of course, the society does not want to be responsible to the new purchasers. They don't want to be responsible for RERA and for compliance of this. They don't want to have any possibility of damages to any future purchaser. So therefore, you must take an indemnity from a developer that all risks, costs, construction issues are all the responsibility of the developer. Supposing there's an incident on site and something happens to a worker, all of this should be taken care of by the developer. A termination clause is also extremely important. Although there are judgments to say that even if there is no termination clause in a development agreement, there can be a termination if there's a major breach. Instead of going down that route, it's much better to have a clear termination clause. So at the very beginning, the first stage before a member vacates, after the development agreement is signed, you'll tell the developer at least go and get a IOD or an IOA. Get your basic plans approved, pay your premiums, then you ask us to leave. You can't ask us to leave until you are ready and your house is in order. So this is the very first stage after signing of the development agreement. Normally this process takes 6 to 9 months by the time they get this IOD or the IOA. Supposing they don't get it in 9 months, supposing they don't get it in 12 months, that means the developer is not even be able to achieve his first stage. So you should have a right to exit at this point itself. Now once he's taken over the project, he's got his IOD, IOA, everyone has vacated, then there are different things. So for example, if the developer goes insolvent or there's winding up proceedings, and this should be an automatic ground for termination. What if he abandons the project? What if he runs out of funds and he just disappears? Then of course, if construction is not carried out on the site for 30 days, 60 days, 90 days, you have to have some clause there that if nobody is working on site, then you should be entitled to terminate the DA. Also failure to complete or failure to comply with the terms of the agreement. So for example, if they don't pay rent and that takes 6 months more, 9 months more, how long will you wait for your rent? So if the rent keeps getting defaulted, at some stage you should have the right to come back. Step-in rights we discussed earlier along with secure premises, that if you need to step in and sell the secure premises, then that's another option. Now these are the main points that one can try and cover in the development agreement. Now we look at the power of attorney. The land and the building and all have always stood in the name of the society, and the land will continue to stand in the name of the society. The PR card will continue to have the name of the society. Therefore, in order to get the approvals, the developer needs a power of attorney from the society. This will be to get all their IOD, IOA, eventually all the way up to the occupation certificate. He will need this power of attorney for everything. Further, he will also need this power of attorney to sell flats to purchasers. Not, of course, the secure premises, but any other premises. He might need the society to be a confirming party, and therefore this power of attorney is valid. One just needs to be careful to make sure that the power of attorney contains 2-3 important clauses. One is that any responsibility of using the power of attorney, of using or misusing the power of attorney, is on the developer. They should be responsible for all costs. Although it's being made in the name of the society, the costs are to be borne by the developer and not by the society. That's the first. Second is the revocation or the termination. So just in case the DA gets terminated, the power of attorney should automatically terminate, because he should not continue to have rights in view of the fact that the development agreement has terminated. Also, the power of attorney can come to an end once the project is completed. Supposing the project goes off well, the building is ready, the occupation certificate is received, then this power of attorney can come to an end, except to the extent of the power required for selling flats. Because the developer may not have sold all his flats till the time the OC comes. He may take 1 year more, 2 years more to sell the flat. So that power will continue, but the powers of construction and applying for permission will come to an end. Now coming to the permanent alternate accommodation agreement. This is a very, very important agreement because this is going to be the title document for each and every member going forward. So if you are a member or you are a confirming party to the development agreement, this will be stamped at a nominal amount. If you are not, this could potentially be stamped at a much higher amount. So this is a document, again, tripartite typically, between the society, each member and the developer. Of course, it has to be stamped and registered. And this will contain the details of each unit. So if you are, say, getting the 3rd floor unit, flat number 301 with 1 car parking, so this will be your title document for your unit. So therefore, once you want to sell, this is the document that you're going to be passing on, because once a building is demolished, your old title document has lesser value because it relates to a flat which doesn't exist anymore. So this is extremely important. And now the question comes in about, okay, so there might be some minor deviations here, because at the time when the basic permissions were received or the IOD was received, to when the DA was signed. The DA was signed before the IOD was received, so there were tentative plans that would have been attached to the DA. But by the time the IOD comes, there might be some minor deviations. Once the builder submits it, the corporation might require some minor edits. So the PAAA, once the IOD comes, will contain the final plans. And the timing is important. You don't want to vacate the building until you have a PAAA. You can't sign the PAAA before the IOD because the plans are not final. So typically during the period after which the builder gets the IOD or the IOA, but before the members vacate, this is the best time to actually sign the PAAA and register it. So once you leave the building, you are completely secure that your document is there with you in the registry. So I think these were the main important provisions relating to the documents. Of course, there are many more that can be added, but these were the main things. Now we'll discuss some of the tax implications pertaining to a redevelopment, which will be handled by Mrugakshi Joshi. Thank you.
Good evening, everyone. I'll be discussing the different provisions of the Income Tax Act. All of us know on a year-to-year basis, we see the budget and we see the complications, and the fact that they change the definitions, they change the, and there are case laws coming every day, we know how complicated tax can be. Even in the case of redevelopment, we've seen a lot of changes in the last 5 years itself. There have been new provisions come, there are new TDS provisions. So one needs to keep in mind all those provisions before we decide how we're supposed to offer it for tax and show it in your tax returns. So I'm broadly going to cover only the main provisions of the Income Tax Act. Section 247 of the Income Tax Act defines what is transfer. Section 45(5)(a) is a newly amended provision which is in respect of joint development agreements. Section 54 is a deduction provision if you are reinvesting in a residential house. And Section 194 IC is with respect to TDS on immovable properties with respect to redevelopment. I'm just going to give a simple illustration which will explain, and I'll go over the provisions and I'll explain it in that manner. Let's say you have a house which is measuring 1,000 square feet and the building goes into redevelopment. You enter into the redevelopment, let's say on 1st April 2024. Now when you enter into the redevelopment, the builder makes certain conditions and also tells you what you may achieve and benefit from this redevelopment. So some of the things which I've not noted is, let's say you have a 1,000 square feet house and the builder promises you a new residential constructed flat which is going to be measuring 1,300 square feet. He also is going to give you in addition to that a monetary consideration of 1 crore. He gives you a monthly alternate accommodation rent of 1,50,000 per month. A lump sum hardship allowance is granted at 10 lakhs. And certain corpus is given to the society of 50 lakhs. In the next year, when you enter into the development agreement, in the next few years, the builder projects the plan and gets his approvals from the MCGM and he gets the IODs and all the permissions in place. On 1st April 2026, he gets the commencement certificate. The very next month, he enters into the permanent alternate accommodation agreement with you, which spells out the exact terms and conditions of your new residential flat. After you enter into the PAAA, the builder asks you to evict the premises. So the individual flat owners are required to hand over the physical possession of the premises of the 1,000 square feet which you owned. Then the builder takes 2-3 years or maybe 5 years to construct the premises. In the illustration which I've given, he's taken 3 years. And if you may see on 1st May 2029, he gives you part occupation certificate. The meaning of part occupation is that although he's promised to construct a building of ground plus let's say 20 stories, he finishes only the 5 floors. If you have a flat on the 5th floor, he gives you a part OC, which means that you are allowed to occupy the flat on the 5th floor. The completion certificate is on 1st May 2030. The completion certificate is when the entire building is complete. And the 1st May 2031 is the full occupation certificate. Now let's understand as to when does a transfer take place under the Income Tax Act. Firstly, what is the meaning of transfer? Section 247 defines transfer, which means sale, exchange, relinquishment of the asset or extinguishment of any rights or the compulsory acquisition under any law and so on. Entering into a redevelopment transaction like this amounts to an extinguishment of your rights in that old flat which is measuring 1,000 square feet. Now the question arises is, if your rights are extinguished, when does a transfer take place? Is it on 1st April 2024 when you enter into the development agreement? Is it on the day of when you enter into the PAAA, which is on 1st May 26? Is it on... Would it be on 1st June 26 when you hand over possession? Or would it be on the day when you receive Part OC? So the date of transfer is different from the date of chargeability under the Income Tax Act. Execution of the Joint Development Agreement on 1st April 2024 does not amount to a transfer because your rights have not been extinguished in the flat on that day. Nor is the physical possession of the premises given on the day of the Joint Development Agreement. So the day on which the transfer is deemed to have taken place is in the financial year 26-27. That is the year in which you have handed over possession of your old house to the builder, after which he demolishes the building and he then starts a construction activity. So the day you hand over possession of your house is the day on which the transfer is said to have taken place. However, under the Income Tax Act, there is another provision which was introduced which is called Section 45(5)(a), which says that although the transfer is taking place on one day, the payment of the tax is deferred to another day. In other words, the chargeability of the capital gains is not on the date of the transfer. Section 45(5)(a) was introduced in Assessment Year 18-19, which states that although the taxable event, that is, a transfer is triggered in the financial year in which the physical possession of the old flat is handed over, or the execution of the PAAA as the case may be, the liability to pay the capital gains tax on such transfer would arise only in the financial year in which the certificate of completion for the whole or part of the redeveloped project is issued by the competent authority. So in our case, if you may see, the Part OC is handed over on 1st May 2029. Therefore, even if the transfer has happened on 1st May 26, you will offer it for tax in your return of income only on 1st May 29. That is when the Part OC is received. The other thing which comes up is deduction of Section 54. Not only in the year of completion are you required to inform your chartered accountant that the possession of the premises have been, the completion of the building has happened, but you are also required to inform him about the claim of 54 which is being taken. While you are giving up your 1,000 square feet house, you are receiving a 1,300 square feet house. And therefore, when you compute your taxes, your capital gains will be computed where you take sale consideration, which is the ready reckoner rate of the new flat, less the cost of your old flat, and the capital gains is derived. And from there you will get deduction under 54. Now when you're taking your sale consideration, you don't only take the value of the 1,300 square feet new constructed flat, but you will also take into consideration the additional consideration that is received by you. So you will take your 1,300 square feet ready reckoner rate plus the 1 crore, which is your deemed full value consideration. So therefore, in the return of income for financial year 29-30, not only are you required to disclose the long-term capital gain, but you are also required to make the claim of reduction under 54. The amount of reduction will be equivalent to the stamp value as explained. What needs to be kept in mind is that the value of deduction claimed under section 54 does not exceed 10 crores. So if you are giving up a flat which is of a high value, and you're going to receive a 1,500 square feet house, your deduction under section 54 will be restricted to only 10 crores. So therefore, what is to be kept in mind is that although the income is chargeable to tax under 45(5)(a), the deduction is allowed only if the possession of the newly constructed flat is received within 3 years from the date of transfer. Section 54 has one more precondition, that the investment in purchasing the new house should be done within 3 years. If the construction is not completed within 3 years and you receive possession of the new flat beyond that period, it is possible that the income tax may take a view that that they may deny your deduction under 54, and they'll say that the possession of the new house is not received within a period of 3 years. So, because the words in section 54 say that it is to be constructed within 3 years from the date of its transfer. Now, transfer has already happened when you handed over possession, which in the illustration shows it is given up on 1st May 26. Therefore, your new house should be received to you within 3 years. Failing which, it is possible that the department may take a view that you have violated section 54 and they may deny that to you.
But it's like a double whammy for the assessee.
It is, but
I mean, what's your fault?
No, but then you are, therefore, it is important that when you enter into the PAAA, you need to see the terms and conditions, you need to see what sort of project it is. Though there are case laws which are allowing the individuals to take the extended benefit of 54, because they say section 54 is to be liberally read and it should not be causing any hardship to the assessee. But everyone is not of that view in the assessing in the department, and therefore that's not how the provision reads. The provision reads 3 years.
But why should an assessee be punished for no fault of his?
Because you are aware that the construction is going to be completed after 3 years, knowing that you've invested in a flat which you know may take 5 years or 7 years, and therefore they do not want to encourage that sort of development. The other two tax angles which need to be seen is when you receive a minimum alternate, a monthly alternate accommodation rent of 1,50,000, how is that taxed in the hands of the individual members? The alternate rent is given for the purpose of rehousing yourself for a temporary period. If you utilize the entire the 1,50,000 which is in the illustration here, if that entire amount has been utilized for the purposes of rent and you are spending 1,75,000, then this amount of 1,50,000 is not taxable in your hands. But let's say a person does not stay in a rented premises which is less than 1,50,000. Then supposing you're paying only 1 lakh outside, then it will be 1,50,000 minus 1 lakh, and 50,000 will be taxed as income from other sources in your hand.
But in that case, we encourage accommodation, personal accommodation. Why one should go for
Yes, but not everybody would land up utilizing the entire rental amount. It is also possible that someone may have a spare house with them and they may stay there. So then what happens is if you do not utilize the rental given to you. It is also possible that the rent compensation which is given as a composite amount. Then in that situation, you have to proportionately divide it over the number of years and offer that for tax if applicable. What is to be seen is that there is when this accommodation amount is given, there is no TDS that will be deducted by the builder while giving this alternate accommodation rent. There is no provision under the Act which says that there is TDS applicable on the rent given. The other amount which is being given by the builder is a lump sum hardship allowance. Now this hardship allowance is on account of the hardship that is faced by the flat owner due to the displacement of the occupants. Such compensation is primarily intended to provide financial relief to society members who face inconvenience and difficulties during the redevelopment process. Accordingly, the said payment is in the nature of a hardship allowance and therefore it is not in a nature of income. There are several judicial pronouncements which are there right now. However, there is no High Court order, but there are several tribunal decisions which have held that any hardship allowance or compensation for inconvenience which is given to an individual member, the same is a capital receipt not subject to tax. Again, when the builder gives you this amount, there is no TDS that is deducted by the builder on this. since there is no provision applicable and there is not, it's not there.
This is different from corpus. Corpus and hardship accounts are different.
So the corpus word which is used is quite often defined by different builders in different ways. If they say we are giving corpus to an individual member, they generally define what is the purpose of this corpus. If they say it's towards rent or it's towards hardship allowance, then we as individual members or as a society, you should ask for a breakup. Otherwise, the entire amount would be deemed to be a part of your consideration. And then they'll say, oh, this is the whole thing should be taxed as capital gains. However, if the breakup is provided, then it allocates the nature of the income towards it. So it needs to be allocated in that manner. The other amount which is given by the builder is corpus money which is received by a society. Now earlier what used to happen is the society would transfer the development rights in favor of the builder. Against this, the builder would give a compensation to them, which was not taxable earlier. And the reason for that was it was in the nature of FSI TDR, which never had a cost. So as per the Supreme Court decision in the case of BC Srinivasan Shetty, if it has no cost, then the amount received by the society is a capital receipt not subject to tax. However, there has been an amendment to the Finance Act 2023, where they are saying that if it's any kind of right which is intangible in nature, the cost will be taken as nil. Which means now if a society receives any money for the purposes of transferring of this FSI and TDR, that amount would be deemed to be capital gains and the cost will be taken as nil. So it will be taxable in the hands of the society. Therefore, it's probably advisable not to take large sums of money in the hands of the society, or else they would have to pay capital gains tax. In the present case, the entire corpus money of 50 lakhs that is the society receives on account of transfer surrender of FSI TDR would be taxed in the hand as long-term capital gain. If the corpus monies are received for reasons other than TDR and FSI, and there's no allocation being mentioned for what it has been given, then it is possible that this entire amount would be taxed in the hands of the society as income from other sources. And the last I would want to talk about is with respect to the TDS, which is under section 194 IC. As per section 194 IC of the Act, the developer is liable to deduct TDS at the rate of 10% only on the amount of the consideration that is received in the form of money. As you can see, the monetary consideration is 1 crore. So therefore, the builder would only deduct TDS on this 1 crore, and that would be recovered by you in the form of refund when you file your returns. I would not like to complicate the issues by taking about other provisions, but these are the main provisions of the Income Tax Act which would probably broadly give a view about it. Thank you.